Good afternoon, Your Honors.
Okay. May I interrupt Justice Javier because I'd like to ask a few questions since we're dealing with COA reports. This adverse finding by COA on the balance sheet of PhilHealth, were they subjected to audit observation memo?
Yes, Mr. Chief Justice.
And they were addressed by the PhilHealth management
They were.
before coming
Your Honor.
out with the financial report?
They were, Your Honor.
Okay, you may proceed.
Thank you, Your Honor.
My next question is the balance equity of PhilHealth in 2022 of 26 billion plus. Based on the observations of COA, may not be accurate, Mr. Commissioner.
For this calendar year, Your Honor, COA issued an adverse opinion considering that the interplay between the assets and the liabilities were materially misstated, resulting in a net equity that the net equity would be a balancing figure to simplify things, Your Honor. However, Your Honor, the main disclaimer was with regards the ICL. Your Honor, just to dispel what the nature of the ICL is it is not simply a liability. What the ICL is the difference between the discounted value of inflows and the discounted values of outflows. If I may direct your attention to a more recent report of the COA, the ICL, the definition is found in the notes of financial statements, note number 22. In simple terms, the ICL takes into account future collections of premiums and also future disbursements for claims benefits and other expenses. In effect, if the discounted value of your inflows is more than the discounted values of your outflows, there is no ICL value to talk about because our net discounted value would be positive. However, the reverse would be if the discounted value of your inflows or revenues is less than the discounted value of your expenses, primarily claims benefits, then an ICL would be set up. However, Your Honors, what we have here for PhilHealth, the main point of disclaimer or the reason why COA has been issuing either a disclaimer or a qualified opinion is the fact that we could not readily ascertain the level of the ICL that PhilHealth should present in its financial statements. If I may direct Your Honors to your attention to page 52 of the notes to financial statements, or the following page thereof, page 53. Page 53 lists down the assumptions that were used by the actuary in coming up with the ICL values. If I may, Your Honor. Note 25.4, which is found in the notes to financial statements, particularly page 53 thereof, of the audited financial statements of PhilHealth for calendar year 2023, lists down certain assumptions. For the record, if I may, Your Honors, the change in the estimate are due to the following. The first group says increases in outflows and future benefit payments. And there are 5 matters of enumeration in there. But if I may direct your attention, Your Honors, to the next grouping, which is the decrease in inflows or future contributions. The first assumption there is a reduction in government subsidy. So, Your Honors, just to reiterate, the ICL is not purely liability. It is really the gap between discounted inflows and the discounted outflows. The main reason why COA finds the ICL computation not reliable, but COA could not pinpoint the true number, is the assumptions that are made to come up with the ICL. And if I may point out likewise, the very first assumption on the reduction of government subsidies comes to a point where you may have an ICL computation where if the assumption is 0 subsidies from government, therefore we only have contributions from the paying contributors, you will have a very large ICL. However, the reason why COA also makes a disclaimer is the ICL for indirect contributors is funded, supposed not to be funded by the paying contributors. If we take a look at the entirety of the inflows are subsidies or appropriations by government, and the mechanism in there, in the law itself, Your Honors, Section 10 and Section 37 of the Universal Act itself mandates the Department of Health and the PhilHealth to actually request for a supplemental budget to comply or to achieve what is laid down as programs of the Act, such that if the supplemental budget mechanism is utilized by PhilHealth, in the event where your indirect contributions are less than what government actually pays for the indirect beneficiaries, PhilHealth and DOH should actually come in and request for the supplemental budget. If it does its mandate, what will happen on an ICL computation is that it should be 0. The net present value or the discounted value of inflows and the discounted value of outflows for indirect contributions with the supplemental budgeting feature should actually zero out. If we take a look at the ICL computations for direct contributions, what we have, Your Honors, is a history where PhilHealth's contributions, meaning premium collections, as against the claim benefits, the gap is actually a positive gap. Your Honors, that's the reason why we have been studying a more reasonable approach to the ICL. And Your Honors, if I may, we have the same occurrence with SSS and GSIS. With the evidence, although external to the case, but PhilHealth not being taken into isolation, the ICL levels for these two other institutions actually make the members' equity of these two corporations negative as well. So, if Your Honors, maybe advancing a question, Your Honors, is why is the nature of the ICL? So that as a briefing, Your Honors, the ICL came about because of a standard of accounting reporting, where sometime in the year 2020, the Department of Finance, in coordination with COA, in coordination with Sisip Guares Velay and Company, an auditing firm, and in coordination with the IMF, took into account possible contract risk exposures of SSS, PhilHealth, GSIS, PhilGuarantee, and including the other government financial institutions, which were under contract to give social benefits. The statement in there for ICL focused on setting up insurance contract liabilities for paying members. That was a very clear statement issued by then Secretary Dominguez in the year 2020. Such that on this note, there was a requirement to set up the ICL to check the health of these entities in complying with their social benefit obligations, because that has been a worldwide practice. It was applied to PhilHealth, but the application to PhilHealth may have to take a bit of divergence. PhilHealth, because of the Universal Health Act, in fact, this started in Republic Act 7875. Republic Act 7875 made PhilHealth not simply purely membership coverage. There was an indigent coverage in 7875, way back in 1995. But the funding for the indigent sector was not coming from the national government. It was coursed through the local governments. So that was a different case. But in 2019, when the Universal Healthcare Act came about, PhilHealth became a bit of a hybrid. It had purely members, then it had also the indirect contributors. If we take a look at the purely members part, based on its history, the ICL, now knowing it to be the discounted value, would not be set up because at this present time, there is really a very wide gap, positively, between premium collections and benefit claim payments. However, for the ICL part on the indirect contributors, if there is no subsidy or there is no GAA counterpart, it would be true that the ICL is negative. But the assumptions that are found in the ICL computations take out or reduce by making the assumption that there is a reduced government subsidy. In other words, a GAA provision lower than what PhilHealth should have spent. If the assumption now comes into play where PhilHealth and the Department of Health took upon themselves the mechanisms of requesting for a supplemental budget, the worst case scenario should be zero ICL if government puts up the deficiency required for the claims benefits expense, Your Honor. Thank you, Your Honor.
Thank you, Mr. Commissioner.
Thank you.
So what is the status now of PhilHealth? Does it have, with respect to its ICLs, considering that the subsidy of the government is unpredictable?
Your Honor.
So will it result in a positive ICL or a negative ICL?
Your Honors, if PhilHealth and the Department of Health do not employ the supplemental budget mechanism, that will result to a negative ICL on the part of the indirect contributions.
Right? Is that good to the solvency of, or the ability of PhilHealth to pay its liabilities to its members and indirect beneficiaries?
The budgetary requirement, Your Honor, is required by law for government to fill in. However, Your Honors, aside from the supplemental budget features that we find in Republic Act 11223, government has also put itself as under a sovereign guarantee because Republic Act 7875, which created the PhilHealth, actually guarantees that the social benefits under the Act should be called in by government. If we take a look at PhilHealth in isolation as a private corporation, which should not be guaranteed by government, if it continues that it has to pay more without any other subsidy, the worst case scenario happens. We have a corporation where the paying members actually subsidize the non-paying members because the access we cover every Filipino.
Commissioner, thank you very much. But I just want to clarify this. All right. The GAA, Section 1D specifically, requires GOCCs, including PhilHealth, to review and reduce. With respect to PhilHealth, review and reduce to produce funds that may be transferred to the Department of Finance. Does that entail reopening the books of PhilHealth?
Your Honors, reopening the books means we adjust what the books present.
Yes.
Your Honors, if I may, the financial statements, but taking out what COA reserves as
No, I'm
non-reliable.
talking about, Mr. Commissioner,
Yes, Your Honor.
about the directive of under the GAA, okay, for GOCCs to review and reduce financial obligations for the purpose of transferring funds to the Treasury to finance unprogrammed projects. In doing that, does PhilHealth have to reopen its books and renege on some obligations that it has already incurred? Because it's reviewing past transactions.
Yeah.
Yes?
May, Your Honor.
Yes.
Your Honor, the books need not be reopened. The GAA is effectively for 2024. The financial statements of PhilHealth, Your Honor, as of 2023 stands. The directive in the GAA, Your Honor, would take effect in 2024. The transactions for 2024 are still
Excuse
subject.
me, Mr. Commissioner. The provision of 1D says that the review and reduction should be done on the financial obligations of PhilHealth in 2021, 2022, and 2023.
Your
For the
Honors,
purpose of producing funds to finance the unprogrammed projects of the government under the 2024 GAA.
Your Honors, the amount or the review would mean simply to use the prior years as a basis, but not exactly to reopen the books, Your Honor. It's like taking a look at what was the history of PhilHealth as far as certain reserves, as far as funding, as far as expenditures. The GAA makes mention of taking a look at the reserves, if I may, Your Honor, and just to refer to the provision of the GAA. Your Honor, my apologies. I can't seem to find my copy. But if I remember right, Your Honor, the setting of the review, or one of the factors to be considered in the review, would be the amounts of expenditures or disbursements for the previous years. So this would also be the basis of looking at the fund balance required under the GA, Your Honor.
Resulting from the review and reduction of their reserve funds. Reserve funds, Mr. Commissioner, the money that was transferred to the Department of Finance included funds coming from the budget of PhilHealth in 2021, 2022, and 2023.
Your Honor, if I may. The reserve can be viewed as a point of cutoff, but the review of prior years could just be used as considerations of factors to make a reasonable determination regarding what reduction is required for the purpose of GAA, Your Honor.
Right. So where did PhilHealth get the money if it did not reopen the transactions that already took place in 2021, 2022, and 2023? Where did it get the funds?
Your Honor, the requirement, and especially for Republic Act 11223, in Section 11 mentions of a reserve fund. The reserve fund, Your Honor, the mechanism in the reserve fund, as how COA takes a look at it, is there are funds for current year operating expenses, and there is what we technically call the reserve fund, which should not exceed 2 years of program reserve funds computed actuarially. Your Honor, if I may, the reserve fund indicated therein is a reserve that is set by the Board of Directors of PhilHealth. But the limit is imposed by the law not to exceed 2 years' worth of program funds, actuarially computed. So we have, Your Honors, a scenario where, as of 2022, or as of, assuming, Your Honor, 2020, if we have accumulated revenues, Your Honor, of roughly 450 billion, just rounding off the numbers, Your Honor, of 450 billion. If the reserve fund has been set by the board at the level of 250 billion, because the range allowed by the board to be set is 0 to 2 years. So if the board says 250 billion, considering the history of our claims, benefits, expenses, then we have a gap between 450 and 250. The reserve proper, Your Honor, is 250. The accumulated reserve, Your Honor, would be 450. That would generate a gap of 200 billion, Your Honor. The reserve fund, Your Honors, that you have seen historically with PhilHealth is what the board sets. If the board sets 0 reserve fund, if they deem that their inflows is more than their outflows, that's within the board discretion. But if the board sets a reasonable level, say, of 250 billion, as against its accumulated reserves of 450 billion, that leaves a surplus or a gap of 200 billion, Your Honor. Speaking hypothetically, just for computations, Your Honor.
Yes, Mr. Commissioner. Setting or assigning a portion of the assets as reserve funds is never discretionary on the part of PhilHealth, because the law uses the word shall. And you speak of excess, not more than 2 times, okay, the actuarial estimate. That is the limit provided under Section 11. But Section 11 also states that should there be an excess, how should the excess be used? How should the excess be used? Yes, Mr. Commissioner, would you know?
Your Honor, if I may.
Yes.
Understanding the limit of the mandate of COA for audit, we delineate the financial presentation and fraud audits, which is the mandate of COA. But when it comes to the business judgment rule of PhilHealth's board, and it is within the law that they comply with, Your Honor. COA's mandate on audit as well as compliance starts there. But when, if we disengage, Your Honor, the word discretion to the business judgment, because we require the boards of all GOCCs to actually think about prudence, think about the business judgment rule, then that is a matter for the board to decide, Your Honor.
Yes, that's why my point is this. When it comes to reserving funds for the program of PhilHealth, it is never discretionary. It's always mandatory to reserve funds to cover the claims of the members and beneficiaries. All right.
I agree, Your Honor.
Yes.
Thank you, Your Honor.
Mr. Commissioner, just one more thing. Considering, of course, we can claim that there is no need or the books need not be opened when you review the transactions that have already transpired in 2021, 2022, and 2023. But for me, that is fiction. You really have to open the books. So when PhilHealth opened the books, its books in 2021, 2022, and 2023 to review and reduce, all right, was not PhilHealth encroaching on the exclusive constitutional mandate of COA to examine and audit the public records, financial public records of government?
If I may, Your Honor.
Yes.
When mentioning the books, opening the books, Your Honor, when COA says we reopen the books, we subject it to a re-audit, Your Honor. But in this case, Your Honor, what happens is the books we deem to be final because we have published the financial reports. The review matter, Your Honor, is simply a matter of taking a look at the historical expenditures in order to validate the possible funds or the possible reserves as it stands at a certain point in time, Your Honor.
Yes. So there may be obligations that were already incurred, which PhilHealth may have reneged from because it has to review and reduce
Your Honor, if I may.
its obligations to a reasonable level.
Your Honor, if I may. On the part of auditors, Your Honor, when we mention obligations, we refer, Your Honors, to the liabilities. If there are liabilities that have been set in 2021, assuming these liabilities get paid even in subsequent years, they remain to be liabilities, Your Honor, and therefore should not be reneged on. However, Your Honor, the nature of reserves is different from liabilities. Your Honor, the liabilities, if your hospitals would claim for benefits, then PhilHealth is obligated to pay. However, Your Honor, in the matter of reserves, which are set up provisions as far as the law is concerned, they are reserves, Your Honor, and do not necessarily partake of the nature of an absolute liability, Your Honor.
Yes. May I read the, Chief, the provision? Okay. Section 11, paragraph G. No portion of the reserve fund or income thereof shall accrue to the general fund of the national government or any of its agencies or instrumentalities, including government-owned or controlled corporations. And then, your basis, okay, what the provision, Section 1D of the GAA states is that government-owned or controlled corporations from any remainder resulting from the review and reduction of their reserve funds. Reserve funds. Reserve funds are sacred under Section 11. Reserve funds are untouchable.
If I may, Your Honor.
Yes.
Going back to my example a while ago, Your Honor, there is a difference between the accumulated revenues and the reserve. Section 11, Your Honor, of Republic Act 11223 mentions two terms: accumulated revenues, which is historically what you have as the difference between premium collections, subsidies, as against the normal operating expenditures or administrative expenditures of PhilHealth, but more importantly, the claims benefits. So the gap between these two from the time that PhilHealth was established is what we can, for simplification purposes, is the accumulated revenues. The reserve, Your Honor, is a different value. It says, out of the accumulated revenues, the first thing we have to disengage, as though it is not to be touched, is just ensure you have enough for current year's operations, just to make sure you're good for the next year. The next requirement is now the reserve, which provides a range between, it makes no mention, the law makes no mention of a floor, but it makes mention of a ceiling. So, going back to the example, Your Honor, if we have accumulated revenues of 450 billion, but we have a reserve set at 250, we have a gap of 200 billion, Your Honor. The restriction of Section 11 lies on the reserve. And that reserve, Your Honor, based on the law, is set by the board. But there is a guide, which is the actuarial computation. Therefore, Your Honor, if we go through Section 11, it says, keep the reserve inviolate. Don't touch. But that is the reserve, Your Honor. The reserve not to exceed maximum, the board, using its business judgment, sets it. Make sure you have enough for current year's operation, then that's it. But do not touch the reserve. Therefore, if the reserve or any income thereof can also be construed, Your Honor, where the reserve is not the accumulated revenue. If the reserve is 250 billion, any income of the 250 billion is something that cannot be returned to government. We now have to make a certain judgment, Your Honors, on what has not been reserved, but which is still part of the accumulated revenues, Your Honor.
Is it also possible that the reserve funds would be less at the end of the calendar year, less than the liabilities of PhilHealth, chargeable to the reserve funds.
That is possible. Your
Yes,
Honor.
that's possible.
Yes.
So if that happens, where will PhilHealth charge the amount that cannot be covered by the reserve funds?
Your Honors, in a situation where your accumulated revenues is not even sufficient to cover your reserve, we have a situation where there is really no gap, where your reserves are your accumulated revenues. And this is one very good example where we have 2019, where the set reserve was to the tune of 360 billion, but the amount that we have solely for accumulated revenues was much less. So that gives us a picture of what can happen, Your Honor. In 2023, Your Honor, it was reversed. You have accumulated revenues to the tune of roughly 464, or let's say 2022, 464, but you have a reserve to the level of 280 billion. Your Honors, if we take a look at 280 billion, assuming we disregard actuaries, because even COA has not relied on the actuarial computation.
Okay.
If we use the rule of thumb and take a look at the historical claims benefits of PhilHealth, if I may, Your Honor, take a look at my figures. In 2021, Your Honor, the claim benefits, the total claim benefits, this includes direct contributors and indirect, amounted to 140 billion pesos. In 2022, and this is borne out by the audited financial statements, Your Honor, 143 billion. In 2023, there was an abnormal drop in the claim benefits to the tune of 74 billion. If we were to disregard actuarial computations and we were to set the maximum ceiling of claims benefits as the program expenditures, if we were to disregard 2023 being a very low number and just focus ourselves on 2021 and 2022, the sum of the claims benefits for these 2 years would be 283 billion, Your Honor, such that without digging further into the business judgment of the PhilHealth Board, Your Honor, the total of 280 billion, assuming that is the amount set up, and we go against 464 billion of the accumulated reserves of 2023, there seems to be a gap where the reserve of 2 years has been complied with, but the accumulated reserves or the accumulated revenues, which is not the reserve, is 464B, Your Honor. There is a gap between the two numbers, Your Honor.
Yes, Mr. Commissioner. Now, PhilHealth is not only obliged to provide reserve funds to pay off the claims of the beneficiaries and contributors. So, to say that a portion of the accumulated benefits or revenues may be considered a free portion. A free portion.
Yes, Your Honor.
Yes, or a surplus is possible only if all the programs mandated for PhilHealth to fulfill have been set up. Because PhilHealth is required to set up certain programs. like a fund to secure benefit payouts to members prior to their becoming lifetime members. Has PhilHealth complied with this?
Your Honor, the
Of
question...
course, you cannot answer that because you're not from PhilHealth.
I'm not from PhilHealth,
Oh,
Your Honor.
yes.
But if I may, Your Honor, you make mention of the lifetime members, Your Honor.
Not the lifetime, yes, becoming lifetime members. Yes, because that is under Section 11 of the UHCA.
Yes.
PhilHealth must also set up the following funds. Has PhilHealth set up these funds before it declares a surplus?
Your Honor, the provision for lifetime members' benefits is likewise accrued, Your Honor. It is part of the ICL. It's a small part of the ICL.
It's a small part,
Yes.
but has it been set up?
It has been set up, Your Honor.
Where is your proof of that compliance? And then to fund a fund to secure payouts to lifetime members, a fund for optional supplemental benefits subject to additional contributions. These are all programs that are required for PhilHealth to fulfill. And then there is a comprehensive outpatient benefit, including outpatient drug benefit and emergency medical services. And to gradually and steadily, consistently upgrade the program of PhilHealth such that on its 10th year, the contributors, those who cannot afford, may no longer be required to contribute.
Your Honors, that would already dwell on the operations of PhilHealth.
Correct.
If I may.
That's why
Yes, Your
we're
Honor.
all about operations here.
Yes, Your Honor.
So how can there be a surplus fund when the programs of PhilHealth required of it to set up under the law have not been set up at all? How can PhilHealth declare that it has surplus funds, aside from the fact that these funds are special funds for special purpose? Are the projects to be financed by the government for construction of the bridge, for maintenance of the roads? Is that a purpose that is akin or even related to the purpose of healthcare?
If I may, Your Honor, if we can let PhilHealth and the board answer and OGCC answer that, Your Honor.
All
it
right.
It goes beyond the
Anyway,
mandate of COA, Your Honor.
Mr. Commissioner, you have offered your wisdom. I'm just afraid that when the case of PhilHealth goes to your office for review, you might be charged with partiality or bias.
Your Honor, the process, as far as COA is concerned, Your Honor, we maintain our independence
Yes, all
with
right.
regards to mandate.
So, Mr. Commissioner,
Yes,
your
Your Honor.
excuse. We don't want to burden you any further.
Thank you, Your Honor.
Thank you.
Thank you, Your Honors.
Yes.
Can I interject?
Yes, please.
Mr. Commissioner, you got appointed as a commissioner when?
Ad interim February 10. Your
2025.
Honor. Yes, Your Honor. Ad interim, Your Honor.
And you're the COA. Are you speaking here now as representing COA or as a resource person?
As a resource person, Your Honor.
But is that correct? You're a sitting COA commissioner.
Your Honor, we are going through the records just as a witness for the records of COA, Your Honor.
But the way I'm listening to your arguments, you are defending the position of the DOF.
Your Honor, this has been a COA discussion also, Your Honor. And we have also reviewed this in light not only of this case, Your Honor, but
So
for the
let me
implementation.
be clear. Are you speaking on behalf of the entire COA when you're speaking to the court now? Or are you speaking only from your knowledge as a COA commissioner?
As a COA commissioner, Your Honor.
So you're
Based
not
on the-
here speaking for COA.
No, Your Honor.
Do you also audit the DOF?
We do, Your Honor.
Then isn't there a conflict of interest here?
Your Honor, we were requested, Your Honor, to discuss the records.
I know,
and the
but you're a
definitions.
sitting commissioner.
Yes, Your Honor.
Don't you think there is a conflict of interest here? You're espousing views. The contending views are to be decided by this court. And now a sitting COA commissioner stands before the court? I don't get it. I really don't get it.
My apologies, Your Honor. This is, I was requested to discuss the contents of the COA report, and objectively, this is part of our records, and we make the statement, Your Honor, based on this.
But you were not COA commissioner at the time these COA reports were made, right?
Yes, Your Honor. But we have the records, Your Honor, and just a matter of explaining what they contain, Your Honor.
Except that you're wearing too many hats.
We
What hat
apologize.
are you wearing?
We apologize, Your Honor. I apologize, Your Honor.
May I, with leave of the Chief and Justice Ami, you mentioned that you discussed this among the members of the COA.
Yes, Your Honor.
So is there a special audit or a regular audit now of the transfer of funds from the PhilHealth to government?
Your Honor,
So was there already a special audit or an audit?
no audit, Your Honor.
Okay, just to clarify.
Yes, Your Honor. This
And-
is, Your Honor, the 2024 audit will cover this, Your Honor, and our financial audit only starts this year,
Yes,
Your
because
Honor.
if there is no audit, then you are already expressing your opinions now, which we did not call you. You were offered by the respondents. And you did mention your opinion. And our fear is for you and for our co-equal constitutional body called the Commission on Audit, that it may affect the partiality. Just for you.
Thank you,
Thank
Your
you.
Honor. Thank you for that note. Well taken, Your Honor.
You are excused.